In this training, we will be addressing the Colorado False Claims Act. We'll talk about what this Colorado revised statute means if and when it applies to your projects and what projects need to do to remain in compliance. A false claim is a knowing misrepresentation to the state in obtaining or performing a publicly funded project. In the case of broadband projects, examples of this could include misrepresenting progress or finances, served locations, speed availability, types of fiber laid, the cost of products or services requested for reimbursement, or many other types of claims. So what is the Colorado False Claims Act? The CFCA is a robust anti-fraud statute designed to ensure that public funds are used for their intended purposes and requires the Attorney General to investigate false claims. This act applies to public funds administered or used by the state agencies, local governments, school districts, special districts, and contractors and grant recipients that operate publicly funded programs, among others. It allows a civil case to be brought by the state against a grantee for misrepresenting progress or finances in the performance of a publicly funded project. There are significant damages imposed on entities that make false claims to the state, a political subdivision, or a private entity that uses public funds. If found liable, a defendant may be responsible for per claim penalties exceeding $28,000. Note that every misrepresentation submitted to the state may be considered a claim. Penalties up to 3 times the cost of damages. For example, if a grant recipient misstates material costs and the amount of $50,000, they may be responsible for damages of up to $150,000 for the false claim. The defendant may also be responsible for attorney fees and costs. It is important to note that damaged public entities are entitled to compensation for their losses. The Colorado Attorney General is required by statute to investigate false claims. The AG enforces the act statewide and in federal courts. The AG has the power to subpoena documents and compel testimony. The AG has significant resources to litigate CFCA enforcement actions, and the AG prizes cooperation with public entities and whistleblowers. So does the CFCA apply to your broadband project? Yes. The act applies to all public funds, contractors, and grant recipients that operate publicly funded programs, including advanced CBO grant programs. So what do you need to do? Avoid making any false claims. Ensure that you fully understand the terms, conditions, and compliance requirements of your grant agreement. Be aware of the legal consequences for making false claims. If you run into a difficult situation, contact your grant manager before making any false claims. The state has the ability to reduce penalties and damages for cooperation with investigations. We are here to help you navigate your project. In summary, the CFCA applies to all broadband grant programs of the CBO. Thank you for your time today and your commitment to learning more about the compliance requirements around the Advanced Colorado Broadband programs. Please reach out to us with any questions at advance_CBO@state.co.us.